Colleagues, the subcommittee has already formed a quorum and it's also time for us to start. So please invite the government officials to come in. We welcome the government representatives. We have the following officials with us: Principal Assistant Secretary for Security, Mr. Vic Yao; the Assistant Secretary for Security, Mr. Huggin Tang; the Deputy Law Officer for Mutual Legal Assistance, Mr. Walsh; Senior Government Counsel from the Department of Justice, Ms. Elizabeth Bernice-Liu, as well as Ms. Carmen Chu, Senior Government Counsel, also from the DOJ. For the outstanding issues, we have a new paper 713/1314-01. Perhaps I should ask Mr. Yao to take us through the paper. Thank you, Mr. Chairman. Thank you, members. As the Chairman said, we issued a letter earlier to address certain queries raised by some members last time, and members would like to have an elaboration from us. First of all, for the MLA in criminal matters Spain order, for Article 3, Bracket 2, in relation to exception to an offense of a political character. At the last meeting, members were concerned about the interpretation by the court. Article 3.2 excludes from the category of offences of a political character terrorist offences and any other offences which the requested party considers excluded from that category by any international agreement applying to that party. This article was included at the request of Spain, and in the past, in other agreements with other jurisdictions, there's also such an article. As regards how the court considers whether or not an offense is of a political character, the court will give effect to the terms of the agreement, which is part of the sub-legislation within the parameter of the Mutual Legal Assistance in Criminal Matters Ordinance, in addition to all the circumstances of the offense. And then for Article 3, Bracket 4, in relation to the discretionary ground for refusal based on offense punishable with life imprisonment or a sentence of undetermined duration, members were concerned about the rationale behind this at the last meeting. And members also asked what factors would be considered. Now, this is an agreement with Spain. If Spain puts up such a request with us, as Spain always provides a maximum sentence for her offences, it is expected that Hong Kong will not refuse assistance request from Spain on this ground. Yet for Hong Kong, we do have offences that attract life imprisonment. If that is to happen, Spain may refuse to provide assistance to Hong Kong if Hong Kong is unable to give such assurance as Spain considers sufficient that the life imprisonment or a sentence of undetermined duration will not be imposed, or if imposed will not be carried out. Hong Kong may explain that we have a review mechanism to allow a conflict to request that life imprisonment be converted into an indeterminate sentence. Article 12 is about an article in the model agreement, that is Article 12.3, which is excluded in this agreement with Spain in this exercise. At the last meeting, members asked why Spain had difficulties. We dug up the records and discovered that Article 12.3 is about the service of a document. The model agreement requires that a request for the service of a document pertaining to an appearance in the requesting party shall include such notice as the requesting party is reasonably able to provide of outstanding warrants or other judicial orders in criminal matters against the person to be served. Spain at that time was of the view that exchange of information could be done through the Interpol, so this article would not be necessary. Spain also expressed difficulties as it did not have such a provision in its other bilateral MLA agreements, so Spain did not agree to the inclusion of this article. That's the reason put forth by Spain at that time. Now let's turn to the Czech order. First of all, for Article 8.3b, on that day, members were concerned why there's such an article. The article sets out the exceptional circumstances when the requesting party may use the information provided by the requested party for purposes other than those stated in the request. The exception is only valid for the prevention of serious crimes and serious threat to public order. As for the rationale behind the article, I'd like to explain that this exception would only be triggered in serious cases of criminal activities or imminent threats to public order. So the focus is on prevention. If an offense has already taken place and some information is to be used for investigation and prosecution, that would not suffice. Another request will have to be submitted. And this article is only for the prevention of serious crimes and serious threat to public order. Another point that I'd like to raise is that this exception, as I mentioned, will only apply to serious criminal offenses and serious threats to public order. So it's only applicable to serious scenarios. So we envisage that very rarely will this be necessary. If the requesting party discovers information that is related to imminent serious crimes, then in order to prevent the occurrence of those crimes or crime, in terms of timing, there may be difficulties in obtaining information from the requesting party. But as I said, we envisage such scenarios to be very rare. Whether or not we have precedents for this, in an approved MLA agreement with Germany, there is a similar provision on the usage of personal data transmitted on the basis of the agreement for the purpose of warding off substantial dangers to the security of the requesting party. And internationally, our MLA agreements with the EU and the USA also carry such an exception, and also between the US and a number of European states, there's also such a provision in those MLA agreements. It's also recognized amongst European civil law jurisdictions and appears in the second additional protocol to the European Convention on Mutual Assistance in Criminal Matters. there's a similar provision. This is introduced in the annex to the paper. The provision, as it now stands, is also consistent with the exception in our data protection law. In Section 58(2) of the Personal Data Privacy Ordinance, it is provided that for express exemption in cases where use of personal data is necessary for prevention of crime. And the principle is that for a new objective, personal data are to be used. And the prevention of crimes and the detection of crimes are also rationale to be used, and also is in connection with legal or law enforcement cooperation between Hong Kong and a place outside Hong Kong, and that offense is an offense under the laws of that place. The spirit of the article echoes the exception provided in the laws of Hong Kong. As for Article 17, in relation to the transfer of a person to another jurisdiction and the civil suit immunity so related. The exception here is different in wording from the model agreement. Members were concerned about whether there's any adverse impact resulting from this. In accordance with Article 6(2) of the agreement, a request pursuant to Articles 15 or 16 in relation to the transfer of fugitive offenders, it will be executed in accordance with the law of the requested party, and the applicable law in Hong Kong is the Mutual Legal Assistance in Criminal Matters Ordinance. Where Hong Kong sends a request to the Czech Republic for the transfer of a person to Hong Kong, Cap 525, Section 17 will apply, that is, the community therein will apply. And Section 23 of Cap 525 will also apply in the reverse direction. And the model agreement is the same in this regard.
It is important to note that the transfer of a person to provide assistance is a completely consensual agreement. The person will be advised of the transfer arrangements, and if he is not satisfied with the arrangements or undertakings, he always has the option of not giving consent, and it will not be forced to be transferred. So the difference in formulation between the model agreement and with the Czech Republic order does not affect the rights enjoyed by the person sought to be transferred. Last point, Article 20, exchange of information or provision of spontaneous information. In the last meeting, members asked what is the government's policy in resorting to that provision. This article was included at the request of the Czech Republic because they said that it may exchange information without request under its law. So such information exchange is voluntary in nature. And with such an article, this article does not in any way oblige Hong Kong to provide information. In practice, information is not provided by the Central Authority of Hong Kong, i.e. DFJ, without prior request pursuant to an MLA agreement. However, DFJ has from time to time received spontaneous information from our counterparts in relation to offences which might be connected to Hong Kong. So that has happened before. So with that article in place, that is allowed, i.e. the contracting party can actually supply spontaneous information to Hong Kong if needed. And that kind of information may be useful to Hong Kong as well. So much for my presentation on the responses to salient points raised by members at the last meeting. Members, colleagues, any question? Spain Order, Article 3.2, the first point. Offence of a political character. From the legal perspective, say, if we do not include Article 3.2, well, let me put it this way. In the Spain Order, it says here that terrorist offences or any other offence which the requester party considers excluded from that category would not be included as an offence of a political character. Is it true that the court must abide or follow this principle? In our own ordinance, IECAP 525, does it mean that actually our ordinance is different from this one? In our ordinance, it mentions the term an offence of a political character, but no definition has been given there. So to my understanding, the international trend is this. Generally, the court would not consider terrorist offences as an offence of a political character. Well, I think it has to do with the common law interpretation. Now, because Hong Kong is a common law system, so whether it is written down in the law does have an impact on the court's ruling. Is that right? Yes. I've talked to the DOJ. Internationally, the court generally doesn't include terrorist offences as an offence of a political character. So even without this article, that is the trend and that is the interpretation of the law internationally. So the fact that it is put there just serves to make it clearer. Do you have any common law cases which sort of comply or coincide with what you said here in Article 3.2, or else you would actually in effect be changing the interpretation of our law in Hong Kong? Now, I understand that this is the request of the Spanish government. Have you got any common law cases which show this? Mr. Walsh, please.
Mr. Chairman, as my colleague said, there's no clear definition of political offence in our law. It's a common law definition, and it's evolved over time in accordance with the court decisions. And the current trend is not to recognise terrorist offences strictly as political offences. The principle of law that would apply here is that the provision in the agreement makes clear the intention of the parties as regards the interpretation of political offence or offence of political character. And there is the general principle of law that the court will construe the ordinance insofar as it can to give effect to the terms of the agreement. So in considering the provision in the ordinance, in this case regarding offence of political character, it would look to the agreement and and construe it to give effect to the terms of the agreement. So the provision in the agreement, we would say, would clarify for the purpose of the court the extent or the scope of political offence as it appears in the ordinance. But we do accept, I think, that there is some issue here concerning this point. But that's how it's been treated in our previous agreements, and that's how we continue to treat it.
我呢就即係對於
I understand that in some jurisdictions, they are under threat of terrorism activities. Spain was one such country which is subject to or very vulnerable to terrorist attacks. So, of course, when they sign agreements with other places, they would put emphasis on terrorist offenses. So that I can understand. But then when we try to apply this article, we would have to be very clear in our position. I have actually asked the legal advisors of the two sides. In our ordinance, we can refuse assistance if there is an offense of a political character. But then now we signed this agreement with the other party, saying that terrorist offenses are not offense of a political character. Then there be a two-level application, i.e., say if Spain asks for assistance from us on a certain offense, and we say that this is a offense of a political character, then we can or we shall refuse assistance in our ordinance. But then in this agreement, there is this Article 3.2. And then there is also this other side of argument that whatever offenses on which we should not provide assistance, we shall not provide assistance. So if the other party asks for assistance on a terrorist offense, so how will the SAR government deal with it? Shall we provide assistance or not? From the point of the agreement, according to Article 3.2, you must provide assistance because terrorist offense is excluded. But then, well, when you make a reply, you must provide assistance because terrorist offenses have been excluded. So there is two-level application here. So how would the government consider? Well, there is a second level, i.e., when you take the case to the court, how will the court interpret this? How will the court interpret whether it is an offense of a political character? I would think the court will likely resort to the common law interpretation. Or will there be another case in that the court will give ruling on different cases based on the different agreements signed with the different jurisdictions? I think this is a very complicated legal issue here. Well, if you think what I said is not correct, you already have a very clear framework of how to interpret this clause. Please elaborate or give me an answer or response. Or else you must let the subcommittee know how you are going to deal with the situations I mentioned. Now, say if I let you go this time, I endorse this proposal, then there are still many other nations which might propose similar wordings, i.e. including the terrorist offenses here. Because many nations are very concerned about terrorist offenses, especially those nations which are vulnerable to such offenses. So are we going to adopt this approach, i.e., whenever a nation comes forward with such a request, now that we have this precedent with Spain, then we will accept their proposal? Because we let Spain go this time, we have to agree to other similar proposals made by other nations. So I think we would rather stop here and think about all these issues. Mr. Yao, on this particular article, what's the government's analysis of the situation? On page 2, you said the court will be invited to give effect to the terms of the agreement. I don't get it. I don't get whether there is a change to our existing law or whether there is no change. I don't know whether there is a change or no change to our existing law.
In the context of a request for mutual legal assistance, the prohibition on cooperation is for the Secretary for Justice under Section 5. So he's the primary decision maker in terms of applying that ground of refusal. And the government, through the Secretary, is also a party to the bilateral agreement. So it's clear the intention through the agreement that terrorist offences are to be excluded from the definition of an offence of political character, and the Secretary, in exercising his discretion under the ordinance, as I said earlier, would act to give effect to the provisions in the agreement to which he himself, through the government, has agreed. So we see the approach along those lines as being consistent and safe. Whether ultimately there would be a challenge to that through the courts, i.e. a challenge to the decision made by the Secretary either to provide assistance or not, is an open question. The exception appears in other agreements we have, not necessarily in relation to terrorist offences, but exceptions to the offence of a political offence. And to date, there have been no challenges. So,
no, but we want to know the exact effect, or at least the explanation of the government on how they view this agreement will work. Well, because we know that this is we are enacting a subsidiary legislation, okay, and the primary principle is very clear: subsidiary legislation cannot contravene the primary legislation, unless the primary legislation in other form to authorize or have a mechanism to the effect that the subsidiary legislation can modify the primary legislation. Okay, and we have that kind of precedent before. Okay, but it seems that this is only a resolution, but not a modification of primary legislation. So I have a puzzle. What will be the exact effect of having a subsidiary legislation which seems to be inconsistent with the primary legislation?
I'm not sure it's inconsistent.
Or restricting, or
because, as I said at the outset, the ordinance uses the term political offence or offence of political character, but there is in fact no definition of that term. What the agreement makes clear, and we would say it puts it beyond doubt, and it's a matter of clarity, that for the purposes of the ordinance and the agreement with Spain, then terrorism will not be regarded as an offence of a political character. Now,
you mean only in relation to the Spain treaty?
Well, we certainly in relation to the Spain treaty, yes.
No. It must be, because obviously you cannot use this Spain treaty subsidiary legislation to modify the primary legislation definition or restricting it.
Yes. Well, we would say it's not modifying it; that's clarifying the scope of the.
Okay. If you I don't know whether this is the best answer. If you say it is a clarifying, okay, because even in your written answer, you are not saying that. This subsidiary legislation is to clarify the primary legislation definition. But if your argument is that, then maybe you have to submit a lot of cases, a full analysis of at least the very authoritative case law of the definition or interpretation of the definition, so that we know, yes, well, actually we are clarifying, or we are not modifying or changing the primary legislation, because actually the interpretation, the current trend is along this line, as the PS said. So can you supply much richer content of the authoritative cases, so that we know that, yes, this is what the common law means today? I believe that you must have such cases. Whether House of Lords cases or any other common law jurisdiction cases.
Yes, there are a series of cases on offence of political character. They're always quite fact-specific, but we could.
I fully understand the chairman's question, because we have to be clear about what laws we are enacting. Well, the trend is that terrorist offences not to be included by offences of a political nature, and the chairman asked whether behind that expression there's any case law. Well, because in common law jurisdictions, is it a global trend to do so? If so, it doesn't matter for us to enact these subsidiary legislation. It's just a matter of writing these laws very clearly. Otherwise, if we, just for the sake of Spain, change our own definitions, that may be different. Well, if we want very much to reach an agreement with Spain, then we have to know what we're doing. It's not just Spain. We did have other precedents. Oh, yes. But probably previously we did not specifically look into this issue. Well, Mr. Chairman, we understand you. Any other questions from members on this? If not, I'll proceed to Article 3.4. Well, let me be more straightforward. There's no equality in this agreement with Spain. If we do not have a maximum sentence for a particular offence, then theoretically under the agreement, the other party can refuse to assist us. But on the contrary, we do not have such a request. So we'll still assist Spain. But we're not afraid, because for Spain, in their own system, they do have a determined duration of sentence. So it doesn't matter. We know it. We know that there's a little bit of inequality, but we know what the inequality is. Am I correct? Oh, yes. I think the so-called inequality mentioned by you not just apply to this particular subsidiary legislation. It occurs in other legislations as well. Well, but in this particular order, there's inequality. Well, in Spain, they do not have any imprisonment related to undetermined duration. In Hong Kong, we have life imprisonment, and both sides know this. Well, given this rationale for discretion, which is requested by Spain to be added into the agreement, both sides know the sentence of duration on both sides. Well, here you say that we have a reviewing mechanism. And we can explain this to Spain. When we ask for assistance from the other party, the suspect may not have been sentenced yet. So we can tell the other party that we have a reviewing mechanism. Well, I don't know how many precedents we have on this. That is in relation to undetermined duration of sentence. Well, Mr. Leung is here. He's very familiar with this. Well, if we can tell how many people under sentence of undetermined duration there are, we can tell the other party the number, and at the time of review, we may already know the determined duration of sentence already. That would be easier, and we'll have stronger arguments. Here, we can only take it or leave it. Between Spain and us, we know there's a little bit of inequality. Well, Mr. Chairman, you are totally correct. We did explain to them that there's such a reviewing mechanism. But this is just to provide information to them. But of course, as you said, Mr. Chairman, in Hong Kong, there are quite many cases in which, even though life imprisonment was meted out, eventually the sentence was of a determined duration. I think we can tell Spain these precedents. In accordance with the provision here, so long as the sentence is of undetermined duration, they can refuse. Murder, what are the offenses? Murder? Then it's strange. Well, between us and Spain, there may be a deadlock on such cases. Murder and treason also. Treason also attracts life imprisonment, isn't it? Well, there's no double conviction. Murder, well, murder is rather common. Extradition, assistance, etc. may be the subject of requests. Well, the argument for discretion is the same. It's not to transfer the person, but to provide information. But the result is that the person may be subject to life imprisonment or capital punishment. And there may be human concerns. And so it said that special treatment can be considered. I think life imprisonment is different from capital punishment. Take, for example, murder, which is a serious offense in any jurisdiction, and any jurisdiction would like to have assistance from another party. But theoretically, murder itself may result in a deadlock. Well, this can form an excuse or reason for refusal. Well, this is rather strange. Terrorist attacks may lead to murder, but they can exercise discretion and reject our request. Well, of course, murder may not be the result of terrorist attack. Anyway, we know the situation. Colleagues, any more questions? Well, just now we're discussing a major issue, I believe. Perhaps we should await your written reply, and then I'll ask colleagues whether we need another meeting. Well, if colleagues consider the authority cited very authoritative, then we may not need another meeting. Well, the clerk will liaise with you, so we'll get your information first, because this is a rather important viewpoint. If there's no other business, Clerk, do we have any other business? Colleagues, any other business? No, the meeting adjourned. Thank you. Well, after reading their information, it may not be necessary to call another meeting. We'll do it by circulation first.